The state of Illinois arguing in federal courts that the modern-day weapons were not what the founding fathers of the Second Amendment thought when they thought about the right to keep and bear arms, and therefore the Illinois law banning certain types of semi-automatic weapons and magazine capacities is constitutional. Good morning, Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. And it is, of course, a Friday where we've got about 1,500 pages of stuff pouring through the federal court system in the Southern District as they have filed their response to a preliminary motion for injunctive relief. You got 4 different cases down in the Southern District of Illinois that have been combined by federal Judge Stephen McGlynn. And that means that you've got this consolidated brief schedule. So the state had until yesterday to reply. They replied with about a 70-plus page reply, which we're going to touch on some of the highlights here. But they also replied with about 1,500 pages of different types of schematics and all kinds of weapons and attachments and magazines and descriptions and, again, all sorts of different types of weapons laid out in this filing. That's just one exhibit. You've got other exhibits where it's just stacks and stacks and stacks of statistics and historical analysis. And all of this coming through the federal court's filing here with Illinois' gun ban being challenged by the Illinois State Rifle Association, by the National Shooting Sports Foundation, by the Federal Firearms Licensees of Illinois, and by private citizens, all while the state's defending their law to ban the sale and possession of these weapons. So let's go through some of what ultimately is laid out in their arguments. Among the arguments the state makes, they argue that certain magazines and firearms were not in common use when the Second Amendment was ratified back in 1788. It says that the weapons banned are not commonly used for self-defense today. So that's, again, kind of, I think, a go-to argument they're going to be making in court is that an AR-15, for example, is not a self-defense weapon. So we'll hear some of the response to that coming up. But also, sale and ownership numbers do not show commonality or use, they argue. Other arguments, they argue that the history and tradition allow regulation of the law to address dramatic technological challenges and unprecedented societal concerns, the state argues. They also argue that during the founding, dangerous and unusual weapons were restricted. And they say that the law is relevantly similar to historical regulations. So, again, part of this 70-plus page brief that they filed in response to a motion for preliminary injunction, they said plaintiffs claim the Second Amendment, as interpreted in the New York State Rifle and Pistol Association v. Bruin case, gives them the right to buy and sell this weapon of war, they say, and others of equal potency, and the state argues that ruling does not. So you're going to hear a lot, again, about the particulars in the Bruin decision, which is the case out of New York that is a recent U.S. Supreme Court precedent leading to kind of a reevaluation of sorts. So the state recognizing that is now some of the ways courts need to view Second Amendment challenges, but they argue that it doesn't do away with gun restrictions at all. It also goes on, the state argues that the most commercially successful weapons restricted by the Act are the AR-15 rifles, and they argue that M16s in every way, they're similar except for one. They say the ability to toggle between semi-automatic and automatic. Because, again, the consumer AR-15s, they have just a safe and a fire. Where with the M16, for instance, which is a different caliber, I believe. Some of you who are more versed in the calibers, again, I don't have an M16, so I don't know what the caliber is. But either way, the firing mechanism for M16s in the military has the safe, fire, burst, and full auto. Consumer only has fire and safe, not burst or full auto. But regardless, they say that's the only difference between the M16 and the AR-15. Meanwhile, they also say that plaintiffs cannot meet their burden of showing assault weapons and large capacity magazines are arms protected by the Second Amendment. They say large capacity magazines are accessories, not arms, and they're neither independently capable of nor necessary for self-defense. So you don't need a magazine for self-defense, they say. It's not going to protect you. They also argue that an AR-15 is not for self-defense. They go on to say that the magazines augment the lethality of firearms by reducing the frequency of reloading in battle or during the episodic massacres that now punctuate modern American life. And I think that there is going to be accentuated quite a bit in other arguments you hear, and it was definitely something that was a ongoing issue for those who passed this law, and pointing to the Highland Park Independence Day parade shooting with a suspect there using a AR-15 type rifle with multiple magazines of 30-round clips and being able to reload quickly. So that's part of this episodic massacre that they say punctuates modern American life. The state also goes on in their 70-plus page briefing. The assault weapon restrictions by the act are not commonly used for self-defense. Again, that repeats several times. By design and in practice, they exist for offensive infliction of mass casualties, according to the state. They also argue that this is exactly such a case. The act responds to utterly modern concern born of dramatic technological change, mass shootings perpetrated by lone individuals armed with assault weapons and large capacity magazines capable of carnage at a level inconceivable to the framers of either the Second or 14th Amendment. So making the argument that they didn't have these particular semi-automatic weapons back in the 1780s. They also say, consistent with historical tradition, the federal government passed a 10-year ban on assault weapons in 1994 in response to growing threat of mass shootings, and because that same escalating threat, Illinois has joined 8 other states, the District of Columbia, and numerous localities in banning their sale now. They go on to say that, they note the Bruin decision clarified the analytical framework that courts should use when addressing Second Amendment issues, but they said it did not have the conclusion of saying other courts were wrong in upholding weapons restrictions. It goes on to also say plaintiffs downplay the capabilities of assault weapons subject by the act by differentiating between semi-automatic and automatic rifles. So that's just some of the highlights of sorts from the 70-plus page brief they filed. However, again, you go into some of the other exhibits. There are like 14 different exhibits, and it's just page after page after page of weapons. And this is from a list that the judge ordered the state to ultimately do and provide a list of all items banned. But there were also a ton of pages of graphs and charts and statistical analysis and consultants, the state says, that are getting paid upwards to $450 an hour. One individual's getting paid $1,600 a day to travel and provide testimony. So you could see that they have about 5 or 6 different consultants that are getting paid hundreds of dollars by the taxpayers because it's the state that's defending the state's gun ban. So taxpayers are footing the bill for this. So a lot of stuff to pour through there when it comes to the statistics, when it comes to the weapons, when it comes to the arguments. That was filed yesterday by the state in defense of the state's gun ban against a motion for preliminary injunction. So what are the next steps here? Well, I chatted with Todd Vandermeide, a gun rights advocate. He's working alongside the federal firearms licensees of Illinois, who are plaintiffs in one of the 4 cases here. We'll hear a lot of what he has to say in reaction to this 70-plus page brief, and then the literally 1,400-plus pages of different types of notes, of stats, of charts, of news clippings, of historical context, and more. So stay tuned. That's still to come here on WMAY. I'm Greg Bishop. It is Springfield's Morning News on 92.7 WMAY, Springfield's News and Talk. And at some points, I'd love to hear from you, and you can always call in live and local at 217-629-7970. Again, 217-629-7970. Much more coming up. Stay tuned. Been looking at all of the weapons that are listed and all of the statistics that are offered for why the state should be allowed to limit the access of certain firearms. And this, as you've got also President Joe Biden, who's vowing to ban assault weapons. President Joe Biden pledging in a speech this week that assault weapons be banned. The critics quickly pushing back. But individual states doing this, including here in Illinois, we've had an assault weapons ban in place, or a ban on certain types of semi-automatic weapons that have been in place, again, since January 10th of this year. Somebody notes on YouTube that we've got, 53 days of the ban in place, and a ton of different lawsuits that have been filed. We've been looking closely at the litigation filed in the Southern District, 4 lawsuits that have been filed there. You had the state file their response with about 1,500 pages of total filings that they put in yesterday. We'll hear from Todd Vandermeiden in some detail in response to a lot of the bullet points here, but I also want to hear from you at 217-629-7970. Good morning. You're on WMAY.
Yeah, basically what Illinois did is they banned that made the weapons illegal with certain cosmetics is all they did. California, when they went in put their ban into effect, the manufacturers, all they did is they got around that, and they took the cosmetics off the very same guns and are selling the very same guns in California that are legal now. So I'm not sure what they're gaining because, all they're going to do is come out with an Illinois legal version to sell that will be the very same gun. It just won't have the cosmetics.
Yeah, and you're talking about a variety, like pistol grips and different types of barrel.
Right, the folding stock, the pistol grip. Yeah. I mean, what's really stupid is there's one certain gun that they banned the tactical version of it, but the very same company makes a hunting version of it. Very same gun. One's an AR-15 style gun. The other one is not. One's legal, one is not. Very same mechanics, works the very same way.
Well, a bunch of Tommy guns banned as well. They provide that whole list, different types of what look like Uzis, with a certain type of shoulder stock, all kinds of other firearms with expanded magazines. It goes on and on and on. I mean, this one filing is 70 plus pages of just illustrations of different firearms.
Right. It's just all cosmetic, though. That's what gets me. I talked to your cohort one day and told him the very same thing. He goes, well, maybe they ought to start banning them others, too. Well, where does it end? That's my question.
No, appreciate it. And stay tuned because we will hear from what Todd Vandermeiden had to say when I chatted with him shortly after he gave an overview of the arguments. So we ask about, the arguments of what's the real difference between the M16 and the AR-15. We ask him about what the state's arguments are when it comes to the Bruin decision. We ask him about what the next steps are and how it's very important, the timing of all of this, what happens next. So stay tuned. We'll get to that coming up here on WMAY. It is Springfield's Morning News on 92.7 WMAY, Springfield's News.